5 seconds to go. Start. This appeal is directed against the Common Judgment and Order dated 28th June 2019 passed by the High Court of Kerala at Ernakulam insofar as relating to RFA number 247 of 2014, whereby the appeal filed by the plaintiff respondent number 1 herein against dismissal of her suit for cancellation of a sale deed and for prohibitory injunction was disposed of with directions to the trial court to decide the suit afresh after de novo trial, essentially with the observations that the evidence necessary for proper determination of the suit had not been brought on record. In the impugned common judgment and order dated 28th June 2019, the High Court has decided 4 appeals arising out of 4 different civil suits but concerning the same contesting parties and involving interrelated issues. Though the present appeal relates only to one of those appeals in the High Court, being RFA number 247 of 2014 that arose from OS number 293 of 2012 in the Court of Subordinate Judge, originally OS number 390 of 2006 in the Court of Subordinate Judge Kollam, but for a proper comprehension of the facts, a brief reference to the subject matter of the said 4 civil suits and findings therein shall be apposite. The relevant factual and background aspects could thus be noticed in brief as follows. The respondent number 1 filed the subject civil suit OS number 293 of 2012 against the present appellant as defendant number 1 and other respondents, her sisters, as defendant numbers 2 to 5 for setting aside a sale deed bearing number 285 of 2006 dated 15th March 2006 registered in the office of sub-registrar. The suit scheduled property consisting of 54 acres and 90 square meters of land and the cinema theatre building thereupon comprised in block number 5 re-survey number 551 of 3 of village district Kollam was originally owned by father of the respondents, and after his demise the respondents and their mother executed a partition deed bearing number 291 of 2003 whereby the suit scheduled property was kept in joint possession and enjoyment of the respondents. A partnership deed was also executed amongst the respondents for running of the said cinema theatre, and the husband of respondent number 1 was managing the cinema theatre named Thrangam Theatre on behalf of the partners. As per the case of plaintiff respondent number 1, on 15th March 2006, the respective husbands of respondent numbers 3 and 5 asked her to reach the office of the sub-registrar for execution of a security bond in favor of a film distributor, and though she made a request for postponing the execution of such document because her husband was out of station, the husbands of respondent numbers 3 and 5 insisted that the said security was to be executed on that particular day itself, or else functioning of the cinema theatre would be affected. As the respondent number 1 had utmost faith and belief in them, she reached the sub-registrar's office and put her signatures on the document as required by them. On 15th March 2006, when respondent number 1 inquired about the accounts of cinema theatre from respondent number 5, it was informed that her share in the said property had already been sold. On hearing the same, the respondent number 1 rushed to the office of the sub-registrar for getting a copy of the document executed on 15th March 2006, and on going through the same, she realized that she was made to sign on a sale deed and not on a security document as told to her earlier. Further, no consideration was received by her, and hence the said sale deed was void and nunest. Stop.